Hello, YouTube. I am Vince White. I am an employment attorney on this channel. We answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. We have a question here from YouTube user Bibindala6740, who says, "Hello. What would my recourse be if I filed a complaint with the New York State Division of Human Rights and completed an interview but stopped receiving communications from the Division of Human Rights? I've tried to contact their various departments for a follow-up, but I've received nothing in return." So, listen, agencies in this area of law can be very dysfunctional. The Division of Human Rights, listen, there are investigators who I will tell you flat out, I know for a fact, they don't even read the charge. We have certain investigators that we read our charges to, because at least we know they heard them. So it does not surprise me that your case might have fallen through the cracks. That happens. There's an issue with government employees in that sometimes they just don't care about people. And there's an issue with these agencies, and sometimes they're not as well funded or staffed as they might be. Often, workplace discrimination, workplace sexual harassment is not a priority for the government in many ways. So this happens more often than you would think. I would recommend that you put together a letter and send it to a variety of people up and down the chain of command of the Division of Human Rights, including the person that you originally spoke with. You need to confirm that your filing has gone through, because it's very easy to blow your statute of limitations. Additionally, while you're doing that, you need to keep in mind your statute of limitations for state and federal court, because you could blow both of those, right? Your EEOC charge needs to be filed in 300 days from the last act of discrimination in New York State, and ideally be filed before that, much before that, because then you'll have additional claims that's still within the statute of limitations under the federal law. Excuse me. Now, additionally, in state court in New York, for a workplace discrimination, workplace sexual harassment claim, you're going to have 3 years as a statute of limitations. You might not want to file in state court, but you need to keep an eye on that statute of limitations, because if the DHR is sitting on your case, if they sit long enough, you could blow some of these statutes of limitation that we're discussing here, and it's not unheard of. It is something that I will tell you employment attorneys keep an eye on, because the agencies can get real funny and real silly and real uncaring real fast, right? So, listen, get it in writing, document, follow up. I understand they're not returning your calls, they're not getting back to you, but try hard copy, try email, try everything you can to get a response. And if you can't, then you may need to file in a different venue. I know it's not a great answer. It's not what you want to hear. You don't want to hear that all your tax dollars are funding this agency that's meant to help you, and it's simply choosing not to. But I don't get to advise you as to how things should be. I have to advise you as to how things actually are sometimes. So that's the reality of the situation. I'm sorry, but that is my recommendation. I wish you the best of luck and great success in your case. If this was helpful, like, subscribe, comment down below. Share the channel so it can grow. Take care, everyone.